BBC reports Twitter sues Elon Musk over $44 billion takeover deal. Twitter is suing billionaire Elon Musk to force him to buy the social media firm. This is going to set up a battle with the world's richest man after Musk said he was going to walk away from the $44 billion takeover deal because of the number of fake bots and spam accounts that are on the platform now. Twitter has filed a case inside of Delaware court where they are claiming the following. Having mounted a public spectacle to put Twitter in play and having proposed and then signed a seller-friendly merger agreement, Mr. Musk believes that he, unlike every other party subject to Delaware contract law, is free to change his mind, trash the company, disrupt its operation, destroy stockholder value, and walk away. The lawsuit is actually blaming him not only of trying to get out of this contract, but also to destroy value to the company and cause some of the damage himself to the company, which I think will become relevant when the case is going to be litigated. So like everybody else, I'm interested in what is going on with this celebrity and one of the smartest people alive today, and came across this video on CNN Business where Professor Scott Galloway, who is a marketing professor, is discussing this lawsuit. He seems to think that Elon Musk is on the hook for more than $1 billion. In fact, he thinks that the settlement is going to be in excess of 10 billion when he's pushed to answer that question in a lightning round. This is what he says.
Will Elon have to pay more than $1 billion to Twitter?
Substantially more.
More than 10?
The answer is yes, and I think it's going to be over 10 billion.
I was wondering if that were really true. Would somebody who's the smartest person alive, who seems to always be winning when it comes to business and science and defying the odds, be willing to do something that was so stupid? I was a little bit skeptical about that, and so decided to take a look at the other side of the argument. And essentially, one side, obviously, is that Musk has no way to back out. So what is the other side of the argument? The other side of the argument is that, and this comes from some answers by Mr. Musk's lawyers, is that Twitter's representation in the merger agreement about the accuracy of its SEC disclosures that are related to the spam accounts and the false accounts are likely to have caused what is considered to be a company material adverse effect. And so that is the keyword that's being used here, called material adverse effect, whatever that means, which may form an additional basis for terminating the merger agreement. A little bit more on that afterwards. While Mr. Musk and his advisors continue to investigate the exact nature, Mr. Musk has a reason to believe the true number of false or spam accounts on Twitter's platform is substantially higher than the amount of less than 5% represented by Twitter in its SEC filing. So Twitter has made these representations in their SEC filings that they have less than 5% of their accounts are fake. And Musk's team is arguing that it could be much greater than that. And that would cause a materially adverse effect. Essentially, just to let you know, from what I've seen, that means essentially what it sounds like. The financials of the company are going to change substantially because of something that has taken place, and that would affect somebody's willingness to buy something at a particular value. There are other elements that I'm not going to read here because it's a little bit long, but they do focus on certain sections of the contract. So Professor Gallery was talking about how there are these airtight contracts that have taken place between Twitter and Musk in this merger agreement.
According to a legal analysis of 1,200 recent purchase agreements, this purchase agreement that he signed is more seller-friendly than 93% of purchase agreements, meaning this thing is hermetically sealed. It's so airtight.
And in response to that, Mr. Musk's representatives say that, and correctly, if you were to look at the merger agreement, which is all public information, in section 6.4 of the merger agreement, that Mr. Musk is entitled to all information concerning the business of the company for any reasonable business purpose related to the consummation of the transactions, and under Section 611 of the merger agreement, to information reasonably requested in connection with his efforts to secure the debt financing necessary to consummate the transaction. To that end, Mr. Musk requested on June 17th a variety of board materials, including bottom-up financial models, a budget for 2022, a draft plan or budget, and a working copy of Goldman Sachs valuation model underlying its fairness opinion. Twitter provided only a PDF copy of the Goldman Sachs final board presentation, but not to all of these other items. And Musk's team would argue they are reasonably requested and they are information that is concerning the business to consummate the transactions of the business according to Section 6.4. It falls under all information concerning the business for any reasonable business purpose. Those are pretty broad terms, but I suppose it will come down to how Delaware goes ahead and interprets this in court. Here's what Professor Galloway mentioned.
Delaware Chancery Court doesn't have a jail, so the question is, how do they enforce it? Although most legal experts will tell you they could enforce this agreement. They could force them to start selling shares in every Delaware incorporated company it has shares in.
He was talking about how would the Delaware court enforce it, and the degree of the extent to which this violation was so egregious that Delaware couldn't necessarily put him in jail, or maybe they could. But if you look at actually why this term material adverse effect comes up, it's pretty easy to find on Google an explanation. So what exactly is material adverse effect? It turns out in the Delaware courts, there is two relevant cases. One is known as the Acorn case, where the case is known as Acorn v. Fresenius, and that is the first case in Delaware holding that party was entitled to terminate a merger agreement based on something called material adverse effect, that keyword that keeps on popping up over here. In a subsequent case in Delaware, Channel Med System Inc. versus Boston Scientific Corporation, known as the Channel case, they did not meet the threshold for Boston Scientific to terminate a merger agreement. Now, some of the factors that were being used in these cases to determine whether or not there was material adverse effect had to do with what was considered to be either a quality matter or a quantitative factor. Something that was a risk of, let's say, a material adverse effect is not enough. What was the most concrete matter was something that was a quantitative consideration. In the Acorn case, a 21% decline in standalone equity value was sufficient to establish a material adverse effect. That might be relevant if we look at the price of Twitter right now and see how much it has declined. Could be used as evidence that, in fact, this is somewhat relevant, although I suppose the position of Twitter would be, no, the market as a whole is going down. As far as a qualitative issue, the question in the courts was whether there had been an adverse change in the target business that is consequential to the company's long-term earnings power over a reasonable period, which one would expect to be measured in years rather than months. Well, it seems to me that the number of users is something that is very important in a social media company. So, of course, you could look at the number of bots in one of these cases and say, well, look, they've got 20% bots or 50% bots. It means they have half as many users. And of course, that should probably deteriorate the chances of making profits in marketing to people that are not, when half of the people don't exist. So certainly the bot case or bot percentage should be able to be a reasonable argument, at least for Elon Musk, in terms of establishing a material adverse effect. According to the Acorn case, 21% decline in standalone equity value alone is sufficient to establish a material adverse event. I'm sure that Twitter and Musk's team will be arguing over whether the fact that Twitter stock is down so much has something to do with it. So on April 25th, the stock of Twitter went up when there was a merger agreement taking place, but you start to see from that point in time that Twitter stock spiked upwards. It went up from somewhere around a close of 47 to a close of 51 right after the announcement on the 25th. And then from that period, over the course of the next several months, the stock is down about close to 30%. Now, of note, Tesla stock is also down around the same amount, around 28%. So I'm sure Twitter could argue, look, whatever the fact that our stock is down, this amount has nothing to do with these bots. Therefore, there's no reason for us to be providing any information about the bots whatsoever. It should not make any difference at all. But Elon Musk's team is going to argue that, hey, look, the stock is down, a concrete number that is a decline in standalone equity overall. Tesla's value is probably irrelevant to the situation because they're not the ones being questioned in terms of having a merger agreement and a material adverse effect. And at the same time, they're going to argue that the fact that there could be bots there is certainly something that they should be entitled to, something that Twitter should have gone ahead and filed in the SEC agreements or disclosures, and something that they should have provided to Mr. Musk. Now, the fact that it's a purchaser or a seller friendly agreement, I don't know if that's going to make any difference. I don't know, but I think there's probably a case for both sides to argue this. It's hard for me to bet against Mr. Musk because Mr. Musk tends to win in these situations. Now, if we take a step back from the lawsuit and we think about this as a purchase, what did Mr. Musk ask for? And this is strategy that he's implementing here. He wanted to know what the bot percentage was. If the bot percentage was 5% or lower, then in fact, it would be good. And he thinks that he could perform this company, but the risk perhaps is just too high if he doesn't know this. I think what he's doing here will be a win-win situation for him. If he's going to argue that they didn't supply the bot percentage, and that's a materially adverse effect, then it's possible they'll have to supply this and prove, in fact, that it's not materially adverse. At the same time, if they do that, he'll be happy to buy the company. Now, they weren't going to provide him this information, but now they're going to have to provide it to the court in proving their case. If they can't do that, or they choose not to, then perhaps it will further support the fact that it is materially adverse. So I think it's a play to try to get them to disclose this information. Meanwhile, Musk has time on his side, and Twitter stock is not doing very well. So they want this to go through. They've really got to figure out how to play this, and it's sort of a game of chess, it seems like, where you have Musk on one side and Twitter and its board on the other. It's kind of strange. You're suing somebody because you want them to take over your company. It's kind of a strange position to be in. Also, perhaps they don't really know anything about their bots. It's not something that they know, but they might be forced right now to go ahead and try to figure this out in order to prove that it's not materially adverse. I can't stop to think that Musk's thought process is not informed by physics. In fact, when he's interviewed, he says that he tries to think of his business decisions in a way that invokes the laws of physics. Well, I was reading about quantum mechanics the other day, came across some interesting information about it, and I couldn't help to think that Elon Musk's strategy is not informed somewhat by this. Or you could look at what's going on with the bot percentage through an analogy from quantum mechanics. One of the principles in quantum mechanics is that things may exist as a particle with definite instance or in the state of a wave. And we can't really know both simultaneously. We can't know both its momentum or its probability inside of a wave and its exact measurement as a particle. It's complicated, but in a very basic level, as I understand it, the act of measuring brings something to a definite state. So the act of measuring something brings something to a definite. Particular case, you've got abilities that, let's say, the percentage of bots is high or low or whatever. It's spread out as possibilities and probabilities. Now, some of those probabilities or the possibilities are at a high level might cause a material adverse effect. And they don't necessarily exist, or a material adverse effect doesn't really exist until we know for a fact what the definite amount is. And perhaps it's not been accurately measured by Twitter. And perhaps by measuring that amount, we are bringing about a material adverse effect or not bringing it about. And in either case, it seems to me that Musk might win. If in fact he gets them to measure it, and that shows that it's a high amount, he'll bring about a material adverse event potentially. And perhaps Twitter will be forced to prove that it's not, and therefore have to go ahead and measure reliably to the extent that they can prove something in court. And in doing so, they may in fact bring about a material adverse event. And so they get caught in this catch-22. Now, if in fact it's a low percentage, well, now Musk has the information that he wants. The uncertainty of the bots is reduced and the risk to him is reduced, and he can go ahead and buy the company. And I kind of thought that was an interesting way to view this. And perhaps that's what is informing the strategy of Elon Musk.